Hello all, welcome to Reflections IAS Academy and welcome to the ICAP Plus program or the Integrated Current Affairs program to integrate your preparation smartly for both UPSC and TSPSC prelims examination. This ICAP program, under this program we had already completed 2 classes. This is the 3rd session, and in these sessions we are doing the current affairs related to Indian polity and governance. So let's start with today's session. First question of today is, with reference to the Parliamentary Committee on Official Language, consider the following statements. So Parliamentary Committee on Official Languages gurinchi ee statements ni chudandi. First statement is, it was set up in 1976 under section 4 of the Official Languages Act 1963, and second is, it submits its report to the Parliament of India. Third is, the first report of the committee was submitted in 1987. And fourth is, states like Tamil Nadu and Kerala are exempt as per the Official Languages Act of 1963 and the rules and regulations of the Act of 1976 అని చెప్పి statements ఇక్కడ. So carefully observe these statements. So the question is, ఇక్కడ question ఏంటి అంటే, you have to identify the statement which is the statements which is or not correct, not the correct statement. So be very careful while reading the question, whether it is asking about picking up the right statements or the wrong statements. Regarding Parliamentary Committee on Official Languages, so the Committee of Parliament on Official Language is the first eప్పుడు set up చేయబడింది. It was set up in the year 1976. Under which section? Under section 4 of Official Languages Act of 1963. So that's why first statement ఏదైతుందో, this is obviously it is a right statement. And ఈ కమిటీ ఎందుకు సెటప్ చేయబడింది అంటే, కాన్స్టిట్యూషన్ లో there is a mandate to promote the use of Hindi, the use of Hindi language for all the official purposes. So Article 351 of the Constitution of India, it says it mandates the government to promote or for the active promotion of Hindi as the official language. So that's why the Official Language Committee has been set up in order to fulfill this mandate given by the Constitution under Article 351. Hindi is not yet a national language, but it is widely used language in most of the states of India. And the first report of this committee was submitted in which year? This committee has submitted its first report in the year 1987. So that's why our third statement, that is the first report of the committee was submitted in 1987. This is also correct. And next, so ఈ committee యొక్క composition ఏంటి అంటే, this committee is chaired by, the chairman of this committee is who? The Union Home Minister is the chairman of this committee, and it is also composed of 30 members of parliament. మొత్తం 30 members of parliament ఉంటారు దీనిలో 20 members of parliament are from Lok Sabha and 10 other members of parliament are from Rajya Sabha. Chairman ఎవరు? Union Home Minister. So the unique feature of this parliamentary committee or this parliamentary panel ఏంటి అంటే, what makes it different from all the other parliamentary panels is, usually parliamentary committees or panels, they submit their report to whom? The Parliament of India. But the unique feature of this committee is that the Official Language Committee is that it submits its report to the President of India, who shall then cause the report to be laid before each house of the parliament, that is Lok Sabha and Rajya Sabha, and send it to all the state governments. So idi official language, the Parliamentary Committee on Official Language unique feature when compared with all the other parliamentary panels or committees. So the second statement of this question, it submits its report to the Parliament of India, is absolutely wrong statement, because it submits its report to whom? The President of India. So if you eliminate the second option, you will get the answer for this question. Hence the correct answer is 2 only is not correct regarding this question. So this is the picture of the 36th meeting of Committee of Parliament on Official Languages. The picture for your reference. And ఇది ఎందుకు న్యూస్ లో ఉంది, why this was in the news and why this question was picked for current affairs is the 11th volume of the report of Official Language Committee was recently submitted to whom? The President of India, not the Parliament of India. And the committee report submit cheyagane, it has triggered many angry reactions and concerns from southern states. Because some southern states, they view this report as an attempt to what? To impose Hindi on them. That's why you might have seen the reactions of many regional party leaders commenting on this parliamentary panel report or committee. So this is about the Parliamentary Committee on Official Language or Parliamentary Panel and the features of this and the news related to this. Second question is, which of the following statement about zonal council are correct? So the question is to pick which is the correct statement or which are the correct statements. First one, there are 5 zonal councils in India. Yes, there are 5 zonal councils in India. Second, zonal councils are advisory bodies and do not have any legislative or administrative powers. This is also a correct statement. Third one, the Union Home Minister is the ex officio chairman of the zonal councils. Yes, this is also the correct statement. The zonal councils are constituted under the States Reorganization Act of 1956. So here basically all these are the correct statements, and the motive behind giving this question is to make you revise about the zonal council. So all the statements 1, 2, 3 and 4 are correct for this question. Let's see what are zonal councils. Zonal councils are basically, these are not constitutional bodies. Ivi constitutional bodies kavu. These are statutory bodies. Why statutory bodies? Because they are formed by an act of parliament. And the chairman is, who is the chairman? The Union Home Minister is the chairman of these zonal councils. And zonal councils, okavela mee question lo, zonal councils are very much mentioned in the Constitution of India and Oste. That is absolutely a wrong statement, because zonal councils are not mentioned in the Indian Constitution. And these are established by which act of the parliament? These are not constitutional bodies. These are statutory bodies. That means they are established by an act of parliament. A act of parliament द्वारा established cheyabadai zonal councils, the States Reorganization Act of 1956. And this act divided the whole India country into 5 zones. That is the northern zone, central zone, eastern zone, western zone and southern zones. And there is one more zone for separately, it is separately devised for the northeast region, that is called the Northeastern Council. So the Northeastern Council, this was created as by a separate act. Anduke question lo ikkada options lo there are 5 zonal councils ante we have done this as, we have considered this as the right statement. There are no 6 zonal councils, because the 6th one or the Northeastern Council is not a part of this Parliament Act. It was formed by a separate Parliament Act, that is the Northeastern Council Act of 1971 ద్వారా form అయింది కాబట్టి this is not considered as a 6th zone. This is considered as a separate zonal council. And its members, Northeastern Zonal Council లో ఎవరెవరు ఉంటారు members? ఏ స్టేట్స్ ఉంటాయి? అస్సాం, మణిపూర్, మిజోరాం, అరుణాచల్ ప్రదేశ్, నాగాలాండ్, మేఘాలయ, త్రిపుర and Sikkim. All the 7 northeastern states are the part of this Northeastern Council. And Northeastern Council, these are mere advisory bodies that make recommendations with regard to any matter of common interest, either it be economic matters or social planning matters between center and states. Either it might be the border disputes, linguistic minorities issues, interstate transport issues, or any matters which are connected with the reorganization of the states. Ivannitiki advisory function ivvadaniki the zonal councils are mandated. So why we are discussing about this in our current affairs is, this was very much in the news because recently the Minister of Home Affairs, the Ministry of Home Affairs, the minister has chaired the 25th meeting of the Western Zonal Council, which is at DU, Daman and DU, or the DU, which is a union territory. So this is about the zonal councils, Important points to note: zonal councils are not constitutional bodies. These are statutory bodies chaired by the Union Home Minister. There are 5 zonal councils, and Northeastern Zonal Council is not a part of these councils. It was made by a separate act of parliament. All these things you have to remember. Any question you might expect regarding all this content. So coming to the third question, which of the following statement are true regarding the PIL or public interest litigation? Many a time మీరు తరచుగా న్యూస్ పేపర్లో చూస్తూ ఉంటారు. సో అండ్ సో పర్సన్ హ్యాస్ filed a PIL on so and so matter, etc. So this is regarding PIL, public interest litigation. First statement says that PIL can be filed only by the aggrieved person or party. Avuna kada? Second statement, PIL is a legal action initiated in the interest of public at large. Is it right? PIL can be filed only in the Supreme Court of India. Is it? PIL is limited to cases involving violation of fundamental rights. Limited to cases. Is it? So select the correct answer. Which are true about, which statement are true about the, underline the word, true about the PIL or public interest litigation. So PIL enti ante basically, what is PIL, public interest litigation? In the interest of public, in the common interest, in the general interest of the public, if you are filing any litigation in the courts, this is nothing but the PIL. And PIL ఏంటి ఇది మన భారత రాజ్యాంగంలో కాన్స్టిట్యూషన్లో రాసుందా లేదా ఏదైనా ఎగ్జిక్యూటివ్ ఆర్డర్ ఉందా అంటే అదేం లేదు. దిస్ ఇస్ PIL is not at all mentioned in the constitution or not mentioned elsewhere in any executive orders. PIL ఏంటి అంటే ఇది this evolved as a part of, there is something called judicial activism. You have to know this, know the difference between judicial activism versus judicial overreach. అంటే జ్యుడిషియరీ యొక్క ఎవల్యూషన్లో ఒక ఇన్నోవేషన్ అని చెప్పొచ్చు, ఒక కొత్త డిస్కవరీ అని చెప్పొచ్చు. ఇట్ ఈస్ డన్ బై ద జ్యుడిషియరీ ఫర్ ద జ్యుడిషియరీ అని అంటారు పాపులర్గా. సో PIL means it is a litigation filed in court of law for what? The protection of public interest. Public interest అంటే ఏంటి? It might be a matter of pollution కావచ్చు. If somebody is erratically or carelessly throwing some garbage on the roads or doing some harm to the environment, you can file a PIL. Or terrorism, road safety కానీ, constructional hazards కానీ, ఇవన్నీ matters. These are part of, these are the instances where we can file a PIL. And any matter wherein the interest of public at a large, ఎప్పుడైతే చాలామంది జనాలు ఈ యొక్క సేఫ్టీ కానీ సెక్యూరిటీ కానీ ఇష్యూస్ వస్తున్నాయని అనిపిస్తే అప్పుడు we can file a PIL. So it is the interest of public is affected, can be redressed by filing a public interest litigation in a court of law. And public interest litigation, it is not defined in any statute or in any act. దీనికి ఇంతవరకు ఏ చట్టం కానీ లేదా రాజ్యాంగంలో కానీ it is not mentioned. It has been interpreted by judges to consider the intent of the public at a large. Okay, and PIL movement అనేది, PIL movement ki who was the pioneer for PIL movement in India? This is one of the most frequently asked questions in the state civil services examinations. That is, it was heralded by Justice P.N. Bhagavati. Justice P.N. Bhagavati is also known as the father of PIL movement in India. In which case? A case law, in the case of S.P. Gupta versus Union of India. So this is about the introduction of PIL. Let's see the options of the question here. The statements: PIL can be filed only by the aggrieved person or party antunaru. This is a wrong statement because PIL can be filed by anyone, can be filed by other than the aggrieved person also. Ante somebody might question, why are you questioning me? Am I harming you? Okay, but the person can file a PIL because even though it is not harming him directly, in the interest of larger public, ఎక్కువ మంది పబ్లిక్ జనాల ఇంట్రెస్ట్ కోసం the PIL can be filed even by the person who is not aggrieved also. So this statement is wrong. Second statement says that it is a legal action initiated in the interest of public at large. Obviously it is a correct statement. PIL can be filed only in the Supreme Court. ఇది సుప్రీం కోర్టులో మాత్రమే ఫైల్ చేయొచ్చా, హైకోర్టులో మాత్రమే ఫైల్ చేయొచ్చా అంటే PIL can be filed in either Supreme Court or in High Court also. In Supreme Courts under Article 32 and in High Courts under Article 226 the PIL can be filed. So this is also a wrong statement because ఇక్కడ ఏమన్నాడు ఓన్లీ ఇన్ ద సుప్రీం కోర్ట్ అన్నాడు. సో ఇట్ ఈస్ అ రాంగ్ స్టేట్మెంట్. ఫోర్త్ స్టేట్మెంట్ PIL ఈజ్ లిమిటెడ్ టు కేసెస్ ఇన్వాల్వింగ్ అంటే ఫండమెంటల్ రైట్స్ వయలేట్ అయినప్పుడు మాత్రమే ఫైల్ చేయొచ్చు అని స్టేట్మెంట్ అంటున్నారు ఇక్కడ. సో దిస్ ఈజ్ ఆల్సో ఏ రాంగ్ స్టేట్మెంట్ బికాస్ ఫండమెంటల్ రైట్స్ వయలేషన్ కి మాత్రమే కాకుండా there are lots of other instances where we can file a PIL. అది మనం చూసాము ఇంతకుముందు. సో this statement is also wrong. So which is correct? Only the second statement is correct for this question. All the other statements are wrong. So let's see some other facts regarding PIL, that is who can file a PIL and against whom. Any citizen of India ఎవరైనా సరే PIL ఫైల్ చేయొచ్చు. దట్ ఈస్ ఎక్కడెక్కడ ఫైల్ చేయొచ్చు, ఏ కోర్టులో ఫైల్ చేయొచ్చు అంటే ఆర్టికల్ 32 రైట్ టు కాన్స్టిట్యూషనల్ రెమెడీస్. ఆర్టికల్ 32 అనగానే యూ హ్యావ్ టు రిమెంబర్ దిస్ ఈస్ రైట్ టు కాన్స్టిట్యూషనల్ రెమెడీస్, part of the fundamental rights, part 4 of the Indian Constitution. And Article 32 is also called what? Also called as what? Dr. B.R. Ambedkar said that Article 32 is the heart and soul of Indian Constitution, or this was also called as mini constitution or constitution within a constitution by Dr. B.R. Ambedkar. The heart and soul of Indian Constitution is the right to constitutional remedies. So under Article 32 Supreme Court lo kuda manam file cheyochu PIL, and under Article 226 it can be filed in the High Court also, and under Section 133 of CPC, that is the Criminal Procedure Code, in the Court of Magistrate kuda manam we can file the PIL. So that's why only in the Supreme Court anedi this is a wrong statement. So everything is fine, but why we are discussing this? Because it was in the news recently. The Supreme Court, it has objected to frivolous public interest litigation petitions. అంటే ఎట్లా పడితే అట్లా without any proper procedure or without any proper reasoning, many people they went on to file PILs to just become famous. అంటే వార్తల్లోకి ఎక్కాలని చెప్పి PIL ఫైల్ చేయడం స్టార్ట్ చేశారు పాపులారిటీ కోసం. సో దట్స్ వై సుప్రీం కోర్ట్ హ్యాస్ objected this. Supreme Court has made a regulation on this filing of frivolous petitions in the name of PILs, and it has also imposed penalties on petitioners for filing luxury litigations. So etla padte atla without any proper procedure or without any proper way PILs file చేస్తున్నారు కాబట్టి Supreme Court recently it has imposed fines or penalties on the petitioners of this frivolous PIL petitions. So this is about the PIL and the news and content related to it. Moving on to the next question of today, with reference to the National Green Tribunal, consider the following. First one, the tribunal is not bound by the procedure laid down under the CPC, under the Code of Civil Procedure of 1908, but shall be guided by the principles of natural justice. Second is, its chairman is required to be a serving or retired Chief Justice of a High Court or a judge of the Supreme Court of India. So these are the two statements, typical UPSC pattern question. Which of the above given statement are not correct? Underline not correct. Let's see about this first before answering this question. NGT, National Green Tribunal, it was established in the year 2010. Under which act? Under the NGT Act or National Green Tribunal Act of 2010. And why it was established? Its purpose was for effective and expeditious disposal of cases relating to environmental protection and conservation of forests and other natural resources. Environment protection ki we can't delay the judgments by spending a lot of time revolving around the courts. So that's why a separate act was passed by the Parliament of India, that is the NGT Act, and ఈ యాక్ట్ ద్వారా నేషనల్ గ్రీన్ ట్రిబ్యునల్ అనేది సెటప్ చేయబడింది. అండ్ దిస్ ప్రొవైడెడ్ ఫర్ ఎఫెక్టివ్ అండ్ ఎక్స్పిడిషియస్ డిస్పోజల్ ఆఫ్ కేసెస్ రిలేటెడ్ టు వాట్, ఎన్వైరన్మెంటల్ ప్రొటెక్షన్ కి సంబంధించిన కేసెస్ ని డీల్ చేయడానికి సెటప్ చేయబడింది ఎన్జిటి. అండ్ ద ప్రిన్సిపల్ సిట్టింగ్ ట్రిబ్యునల్, ద మెయిన్ బ్రాంచ్ is where is at New Delhi. And apart from New Delhi, other tribunals are at Bhopal, Pune, Kolkata and Chennai. Okay, so there are total 5 places where the tribunals of NGT are located. Apart from New Delhi, other places are Bhopal, Pune, Kolkata and Chennai. And the tribunal is not bound by, ee tribunal edaithe undo, this is not bound by the procedure laid down under Code of Civil Procedure. There are certain other tribunals which are bound by the Code of Civil Procedure, but NGT is not such tribunal which is bound by this procedure of 1908, and but shall be guided. So etla guide cheyabadutundi idi, ee code ledhu kabatti it shall be guided by the principles of natural justice or nature's justice. So the first statement edaithe undo ikkada, this is absolutely correct statement. Next, NGT is mandated to make disposable of applications or appeals finally within how many months? 6 months of filing the same. And total strength enta NGT lo sanctioned strength is, it allows up to 40 members. 40 members, indulo 20 members are experts and 20 are judicial members. So this is the basic difference between tribunals and courts. Tribunals lo all the members are related to what? Judiciary. All the members are either judges or lawyers, etc. Judges usually, justices. Whereas tribunals law, there are experts also, experts as well as the eminent people from the judiciary. So NGT lo total 40 members untaru, indulo 20 expert members are there related to the subject and environment, and 20 members will be from the judiciary. And chairman, who will be the chairman? Who is the chairman of the NGT National Green Tribunal? The chairman is the administrative head of the tribunal and also serves as the judicial member, and is required to be a serving or retired chief justice of a high court. Oka high court nunchi aithe either serving aina kavachu chief justice, leda retired chief justice kuda undochu, leda supreme court nunchi aithe a judge of the Supreme Court can also become the chairman of NGT or the National Green Tribunal. So with the establishment of NGT, India has become the third country to set up such a tribunal which is dedicated to environment. First 2 countries enti ante Australia and New Zealand. Third country is what? India, which has set up a separate tribunal to protect the environment. And jurisdiction enti, దీని కింద ఏమేం కేసెస్ వస్తాయి? The tribunal has jurisdiction over all the civil cases లో ఏవైతే which involve substantial questions related to environment ఉంటాయో, ఓకే, అవన్నీ దీని పరిధిలోకి వస్తాయి. And the NGT deals with civil cases under which acts? First, the Water Prevention and Control Act of 1974, the Water Prevention and Control of Pollution Act of 1970, SES Act of 1977, the Forest Act of 1980, the Air Prevention and Control of Pollution Act of 1981, the Environment Protection Act of 1986, the Public Liability Insurance Act of 91, the Biological Diversity Act of 2002. All these are the jurisdictions of the tribunal or the NGT. So the second statement, let's see in the question. Coming to the second statement, its chairman is required to be a serving or retired chief justice of a high court or judge of the Supreme Court of India. So obviously we have just now read that the statement. So this is also correct statement. So దీనిలో both are correct statements, but the question here is you have to pick up the incorrect statements. Hence the answer will be D, or neither one nor two are incorrect regarding this question. So this is about NGT, and why it was in the news is, why we are discussing here in current affairs is, recently Supreme Court has stated that NGT is a subordinate to High Court. It is subordinate to High Court insofar as territorial jurisdiction is concerned. Territorial jurisdiction తీసుకుంటే NGT అనేది హై కోర్ట్కి సబార్డినేట్ మాత్రమే అని చెప్పి సుప్రీం కోర్ట్ హ్యాస్ రూల్డ్ దిస్ రిగార్డింగ్ ఎ కేస్ వేర్ an order has prohibited the construction work at Rishikonda Hills in Visakhapatnam of Andhra Pradesh. So that's why it was in the news, and this is all about NGT, or the National Green Tribunal. Moving on to the next question. Which of the following statements are correct regarding the collegium system of appointment of judges in India? Collegium system, usually this is in the news every year. This will be in the news. Very important topic as far as your examination is concerned. So first statement says that the collegium system was established by 99th Amendment to the Constitution of India. Second, the collegium system comprises of Chief Justice of India and 4 senior most judges of the Supreme Court. Third statement, the collegium system is responsible for appointments and transfer of judges in the Supreme Court and High Courts. Fourth statement, the collegium sends the recommendations directly to the President of India. So you have to pick up the correct or incorrect statement. You have to pick up the correct statement among this 4 statements. Let's see about collegium. Collegium ante enti? Collegium system is also not mentioned anywhere in the Constitution. Collegium is nothing but what? It is the system of appointment and transfer of judges that has evolved through judgments of the Supreme Court, and not by an act of the Parliament or by a provision of the Constitution. So this is also, collegium system is also a part of what? Judicial activism, because it has evolved through the judgments of the Supreme Court. This is not mentioned, neither mentioned in the Constitution. Constitution lo mention cheyabadaledu, and also neither any act was passed in order to introduce this collegium system. And first statement lo what was there? The 99th Constitutional Amendment Act provided for this what? The collegium system. But enti collegium system? It is not it is not related to any act of the Parliament. It was not introduced by any act of the Parliament. So that's why first statement, is it correct? The first statement is wrong, because it was not introduced through any amendment of the Constitution. Rather, it is an innovation of the Supreme Court by its own judgments. So the 99th Constitutional Amendment Act enti ante, it has provided for the establishment of what? NGAC, or National Judicial Appointments Commission, to replace the existing collegium system. But it was struck down, it was declared as null and void by the Supreme Court of India, as it impinged upon the principles of independence of the judiciary as well as the separation of the powers. Judiciary యొక్క ఇండిపెండెన్స్ ని అండ్ సెపరేషన్ ఆఫ్ పవర్స్ కాన్సెప్ట్ ని, డాక్ట్రిన్ ని ఇది వైలేట్ చేసింది కాబట్టి the Supreme Court has struck down the 99th Constitutional Amendment Act to introduce, which was done to introduce the National Judicial Appointments Committee. That's why frequently there is a tussle between the legislature and the judiciary regarding the collegium versus NGAC. Okay. So the Supreme Court collegium is headed by whom? The Chief Justice of India. And దీనిలో ఇంకెవరు ఉంటారు? It comprises of 4 other senior most judges of the court, and a High Court collegium. Supreme Court ki kuda collegium untundi, High Courts ki kuda collegium untundi. High Court collegium is led by whom? The incumbent Chief Justice of the High Court and 2 other senior most judges of the court. See the difference here? Supreme Court collegium lo Chief Justice of India kakunda there are 4 other senior most judges, whereas High Court collegium lo the incumbent Chief Justice of that High Court kakunda there are only 2 other senior most judges. That is the difference between the collegium of High Court and Supreme Court. And collegium system is basically in the content it is responsible for appointments of the judges, transfer of the judges in the Supreme Court as well as in the High Courts. And this was introduced to what? For what purpose? To ensure transparency and accountability in the appointment of judges. And the collegium sends its recommendations to whom? ఇక్కడ మనకు fourth statement లో what was there in the question? The collegium sends the recommendations directly to the President of India. But this is a wrong statement. Enduku ante the collegium does not send its report directly to the President of India. There is a proper channel. First it sends the recommendations to the law minister, the union law minister. Law minister forwards it to the Prime Minister of India. The Prime Minister forwards and asks the President to advise on this. So this is the proper flow, the proper channel of the submission of collegium report to from the the courts and to the law minister, to the Prime Minister, and finally to the President, not directly to the President of India. That's why fourth statement is absolutely wrong statement. So here in the question, first statement is wrong because 99th Amendment Act, it is related to National Judicial Appointments Committee. It is not related to collegium system. So that's why this is wrong statement. Second, the collegium system comprises of Chief Justice of India, 4 more senior judges of the Supreme Court. Just now we have read about the composition. So అందుకే this is what? Right statement. Collegium system is responsible for appointments and transfer of judges in the Supreme Court and High Court. This is also a right statement. And it sends its recommendations directly to the President of India. This is wrong because it does not send its report directly. So ikkada correct statements evevi 2 and 3 are correct. The remaining 1 and 4 statements are wrong for this question. And few more facts about this collegium system are, there are 3 important judicial pronouncements or judicial cases related to this collegium system. ఏవేవి అంటే the first judge's case of 1981, second judge's case of 1993, third judge's case of 1998. Okay, so the present collegium system is based upon the judgment of this third judge's case of 1998. Please do read about this. So this is about the collegium system, NJAC, judicial activism, and the National Judicial Appointments Committee, the tussle between the judiciary and the legislature, etc. Sixth question, with reference to the prison reforms in India, consider the following. Prison reforms. First statement, administration and management of prisons is the responsibility of union government. Is it? Second, the Union Law Ministry and Justice, the Union Ministry of Law and Justice provides regular guidance and advice to states and UTs on various issues concerning prisons and prison inmates. So which of the statements is not correct? We have to pick up the wrong statements among the following. So the correct answer for this question is both the statements are wrong because the administration and management of the prisons, edaithe undo, administration of and management of the prisons is a matter of which subject? It falls under the state subject of the 7th schedule of Indian Constitution. It does not form under the union list or concurrent list. So first statement is wrong because it is given that it is the responsibility of union government in this statement. Second, Union Ministry of Law and Justice provides, this is also a wrong statement because this is not the Union Ministry of Law. This is indeed, in fact, the Ministry of Home Affairs. It provides regular assistance and guidance and advice to the states and union territories on the issues of prisons and prison inmates. So both the statements are wrong regarding this question. That's why statement option C is correct for this question. Why it was in the news? Why we are discussing this is because recently, which bureau? National Crime Records Bureau has released Prison Statistics in India report 2021 and had mentioned about all these things. So the correct answer is option C for this question. Next, coming to the question number 7. Which of the following is the most appropriate description of the term SUPES, sometimes seen in the news? So current affairs question are usually asked in your UPSC exam like this. Sometimes seen in the news, often seen in the news, etc. So what is this SUPES related to? Is it an advanced light combat aircraft developed by DRDO? Is it a remote sensing satellite developed by ISRO? Is it? Are you kidding me? If you know the answer for this question, you might ask the examiner like this. So option C, an AI based tool. It is an AI based tool, that is artificial intelligence based tool, that collects relevant facts and laws and makes them available to a judge. Option D, it is an AI based robot which assists the surgeons in removing the brain tumors. Once again, are you kidding me? No, this is also not the correct option. In fact, the correct answer for this question is option C, that is SUPES is nothing but Supreme Court portal for assistance in courts efficiency. It assists the judges, it saves the time of the judges and also improves the efficiency of the court, and it is an AI based tool, that is artificial intelligence based tool. Supreme Court portal for assistance in courts efficiency. This tool, it collects relevant facts and laws and data and makes them available to a judge in a readily manner, and it is not designed to take decisions, but only to process the facts and data to make them available to judges looking for an input for a decision. So this will produce customized results and also saves the time of the judges. So this is about SUPES. Why it was in the news? Recently, the Chief Justice of India has launched an artificial intelligence based portal called SUPES in the judicial system, which aims at assisting judges with the legal research. So this is about SUPES. 8th question. Which of the following actions are prohibited under the anti-defection law? This is a simple question. Anti-defection law, everybody knows this. Frequently seen in the news, always seen in the news is what? Defection, use of anti-defection law, etc. The Maharashtra crisis, the Maharashtra political crisis, you might have adequately seen in the news regarding the defection and anti-defection, etc. So what are the grounds of defection? Option A, voting against the party whip. Option B, abstaining from voting when the party whip is in force. Option C, joining another political party. All these are the grounds of defection. So all of the above are correct for this question. Anti-defection law, it is important. It is a couple of times or many times asked in UPSC and other state civil services examination. Anti-defection law is mentioned in which schedule of the Indian Constitution? In the 10th schedule of the Indian Constitution. So this law provides for what? For disqualification of MLAs who, after being elected on ticket of a political party, if they voluntarily give up their party membership. So this law is used at that time. And it was included in which schedule? The 10th schedule. Via which amendment of the Constitution? To the Constitution, the 52nd Amendment Act of 1985, the anti-defection law was introduced. So what are the grounds of disqualification? On what grounds a member is disqualified from the House? That is, if a member votes or abstains from voting in such House contrary to any direction issued by the political party without obtaining the prior permission. So this is what called nothing but whip, the party whip. ప్రతి పార్టీకి ఒక విప్ ఉంటుంది. అంటే విప్ మీన్స్ ద డెసిషన్ టు vote for certain candidate or certain party. So if a candidate votes against the party whip, the candidate is liable to defection. And second, nominated member, if he joins any political party after expiry of 6 months, that is also a condition for defection. Any independent member, if he or she joins any political party, independent ga gelchi, if that elected member joins into any political party, then also the person is liable to defection. And if the person also, one more grounds is, if the member abstains from voting when the party whip is in force, approved, this is also a ground for defection of a member. So this is about anti-defection law and its conditions for defection. Ninth question, which of the following is not a power or function of the Election Commission of India? So Election Commission of India extremely important because it is a constitutional body, and constitutional bodies are extremely important for UPSC or any other state civil services examination. So options are, you have to select not a power or function of ECI or Election Commission of India to conduct free and fair elections, fair enough, easy. Granting recognition to political parties, yes. Making laws related to elections, preparing electoral rolls, obvious function of ECI. For this question, you need not do any, lot of research to arrive at a final answer. Just you have to know the difference between the three organs of the government, that is the executive, legislature and the judiciary. What is ECI? Election Commission of India, it comes under what? Which body? Legislature or judiciary or executive? It comes under executive. It is an executive body. It's a constitutional body. Okay. But what is it given in the third option? Making laws related to elections. Laws, formulation of laws or framing of laws. Who will form the laws? Where are the laws formed? Are they formed by the executive or judiciary? They are formed by obviously the legislature. They are formed in the parliament, and executive, it implements the laws, and judiciary, it interprets the laws. Okay. So if you just know the difference between executive, legislature and judiciary, and if you just know that Election Commission of India is not included in legislature or judiciary, rather it is included in the executive, so you will easily identify this, the answer to this question. So making laws related to elections is not the power or function of Election Commission of India, rather it is the function of or the power of the Parliament of India. That's why option C is wrong for this question. So hence the answer is option C. So some more facts about Election Commission of India. Election Commission of India, it is an autonomous constitutional authority. It is responsible for what? Administering union and state election process in India. When was it established? It was established on 25th of January 1950 in accordance with the Constitution of India, and it was established on which day? National Voters' Day. Election Commission of India was established on 25th of January 1950. That's why 25th of January every year it is celebrated as National Voters' Day. And the Secretariat of the Commission is in New Delhi. It administers elections to what? Elections to Lok Sabha, Rajya Sabha, the state legislative assemblies also in India, and also to the offices of the President, Vice President of India. And it is not concerned with the elections to what? Panchayats. So if you are getting a question and a statement, Election Commission of India conducts elections to the panchayats also, then that statement will be absolutely wrong, because it does not conduct the elections to the panchayats, rather the State Election Commission conducts those elections, and even municipalities also in the states. So for this, the Constitution of India, it provides for a separate State Election Commission to conduct the elections for the panchayats and municipalities or the local bodies. And in the Constitution of India, since it is a constitutional body, it is very much elaborated in the Constitution of India, where in part 15 and from Article 324 to 329 of the Indian Constitution, they deal exclusively with the powers, functions, mandates, etc., or matters related to the Election Commission of India. And originally when it was founded, only one election commissioner was there, but after the Election Commission Amendment of 1989, it was made a multi-member body. So the Election Commission, it shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, or the President may from time to time, he may fix or she may fix. And presently, so what is the current situation? It consists of a Chief Election Commissioner, a CEC, and two other election commissioners. So presently, there is one Chief Election Commissioner and two other election commissioners appointed by whom? The President of India. And at the state level lo chuskunte, Election Commission is helped by whom? The Chief Electoral Officer. Chief Electoral Officer is usually an officer of IAS rank. And President appoints obviously the Chief Election Commissioner and the election commissioners. And the tenure of election commissioners, usually the term tenure India law, it is 5 years, but be very, very cautious here. It is not 5 years, the term is 6 years. And up to what age? Up to 65 years, whichever is earlier. And the status gani, the perks gani, the salaries gani, all these things, they enjoy the same salary and perks as the judges of the Supreme Court. And the manner of removal of election commissioner, the procedure to remove them is also similar or the same as the removal of judges of the Supreme Court of India. So this is about Election Commission and the question related to this, answer and the facts related to Election Commission of India. Moving on to the last question of this session. 10th question, what is a private member bill in the Indian Parliament? Although these last 2-3 questions are simple, the content related to these questions is extremely important. Okay, so kindly don't ignore the content related to these questions. So what is a private member bill in the Indian Parliament? The options are a bill introduced by a member of Parliament who belongs to any political party. Is it? Second, a bill introduced by a member of Parliament who is not a minister. Is it? Third option, a bill introduced by a member of Parliament who represents a minority community. Is it? Fourth one, a bill introduced by a member of Parliament who has previously served as a minister. So all these options are wrong, but second option, that is private member bill, is nothing but it is a bill introduced by a member of Parliament who is not a minister. Not a minister. So private member bills are usually introduced in the Indian Parliament by a member who is not a minister. And these bills are introduced by individual members of the Parliament. And a member of Parliament ga undali kachitanga, but he should not be a minister. And these are not by the government. Private member bills are generally introduced on which days? On Fridays. And when the Lok Sabha and Rajya Sabha meet for private members' business. Usually these are introduced on Fridays. And private members' bills, they provide an opportunity for the members to raise issues and concerns that are important to them and their constituents. However, it is very important to note that private member bills have got a very, very less chance to for being passed in the Parliament. And after 1970, no private members bill was passed by the Parliament of India. So this is about the private member bill, which is extremely important for the examination. So this is about today's. These are the questions of today, and these are the answers, and this is the content related to all these current affairs related to Indian polity and governance. We will meet with the next session very soon. So thank you so much.